Dear colleagues, dear guests, today I would like to discuss a case decided by the International Court of Justice, the case of Qatar versus the United Arab Emirates. The judgment was announced on the 4th of February 2021, and it is a judgment on preliminary objections. This is one of the most, or perhaps the most recent intriguing case of the International Court of Justice, and as we will see, for a variety of reasons. There are a number of main themes in the judgment. In the first place, it is the very complex geopolitical context of it. The second is the discussion on CERD, on the Convention on the Elimination of Racial Discrimination. The judgment has also a general impact on human rights law. It has an impact on migration policy. It is perhaps one of the most important migration law cases. And it may have an impact on our political culture, even if this seems a bit awkward. And there's a paradox that the judgment had practically no impact on the parties to the dispute, because when the judgment was adopted, the dispute had already been politically resolved. So let me begin with the map. This is the map of the members of the Gulf Cooperation Council. The Gulf Cooperation Council is a regional organization of the rich oil producing states of the Arabian Peninsula. It includes Saudi Arabia, Kuwait, the Emirates, Oman, Bahrain, and Qatar, but not Yemen. Let us see the facts. In June 2017, the conflict has come into full expression when the Emirates determined that Qatar was a threat to the security and stability of the region and of the Gulf Cooperation Council, that it supported terrorism and the Muslim Brotherhood. It promoted the ideologies of Al-Qaeda and of the Islamic State. So the Emirates have adopted travel bans and ordered the mass expulsion of Qatari nationals from the Emirates. It severed the diplomatic relations. It took measures against the Qatari media, and Al Jazeera was blocked. And then on the 11th of June, some of these measures have been somehow moderated. What is the geopolitics of the conflict? Now, prima facie, we could say that it is a conflict between the Saudi Arabian axis and the Iranian axis, but this is too easy, and I don't think that it is true, in particular because Qatar holds an ambiguous position in the Saudi-Iranian conflict. For instance, it hosts a United States bases on its territory, and not only bases, but the forward headquarters of the United States Central Command, which has military authority over Central Asia, Middle East, and North Africa. At the same time, it supports the Muslim Brotherhood in Egypt, it supports the Hamas, the Islamists in Libya, the political Islam in Europe, and it hosts Al Jazeera. So I would rather explain the clash as between the status quo powers, Saudi Arabia, Egypt, Bahrain, and Qatari revisionism. Qatari promotes some sort of radical and revolutionary Islam. This is an important book on the impact and the activities of Qatar in favor of the political Islam in Europe. It has been written by two well-known French journalists, Christian Chenot and Georges Malbruno. And the book shows in detail the sort of activities that Qatar has undertaken in France. Now, the procedures of the dispute resolution have been manifold. There are many levels in which these procedures have developed, as judicial, as quasi-judicial, and as political. There were proceedings before the International Court of Justice, proceedings before the CERD committee, And ultimately, there was the political process in the Gulf Cooperation Council. There were also proceedings before the WTO and arbitral proceedings, but the categories A, B, and E were the most important. For the rules of the CERD, the communication of Qatar against the Emirates for violation of the convention was admissible. The ICJ indicated provisional measures against the Emirates in July 2018 for aspects relating to family reunification, the studies of Qatari students, and the access of Qatari citizens to the Emirati tribunals, and it asked both parties not to take any measures aggravating the situation. To finish with the facts and the political resolution, on the 5th of January 2021, the Al-Ula Declaration, signed in Saudi Arabia, resolved the dispute politically. It was the 41st summit of the Gulf Cooperation Council, using a coded language which did not refer even to the names of Qatar and the Emirates, but that was the meaning of the declaration. The UN response was positive, and a month later, the ICJ rejected the application of Qatar for lack of jurisdiction. The whole discussion before the court, before the ICJ, was on the interpretation of Article 1 of the CERD, whether the measures of the Emirates constituted racial discrimination against Qatari citizens. The discussion revolved not around the term of race, but around the term of national origin, having the purpose or effect of nullifying or impairing the rights of Qataris. We should also mention here that the convention, the CERD, does not apply to distinctions and so on related to the broader distinction between citizens and non-citizens. However, Qatar tried to argue that the term national origin, for a number of reasons, includes also the citizenship and the nationality in the legal sense. Which were the measures? Travel bans and expulsion orders that would constitute direct discrimination on the basis of nationality. Media bans, again, direct discrimination against corporations based in Qatar. And then the first and the second category of measures result in indirect discrimination on national origin, independent of nationality. Why? Because the measures of the Emirates allegedly had a number of consequences of people of Qatari origin. The measures, Qatar argued, had the purpose or effect of racial discrimination on the basis of the Qatari origin. It had an unjustifiable disparate impact on individuals of Qatari origin, and they constituted incitement of discrimination against Qataris. I repeat again, the race term has not played any role. The court could have jurisdiction on the basis of the compromissory clause, Article 22 of CERD, and the ICJ examined three questions. Does national origin encompass current nationality? Do the measures against media come within the scope of CERD? And then, do these measures, A and B, constitute indirect discrimination based on national origin? The methodological approach of the court was taken on the basis of Articles 31 and 32 of the Vienna Convention on the Law Treaties, ordinary meaning, travaux préparatoires, and practice of the CERD committee as subsequent practice. With regard to the ordinary meaning, Qatar invoked the preamble, and it argued that the convention does not only refer to immutable characteristics, but it is not a static system of concepts, but affords comprehensive protection applicable in different countries, contexts, and time periods. This was a sort of an effort to establish within the ordinary meaning, in a teleological sense, the idea of racial discrimination. But the court dismissed this argument by saying that the persons protected by CERD were protected because of an immutable bond that they had at birth, or an immutable feature, and not on a transient legal bond of current citizenship. And I would say also on religion. Religion is not included within the CERD criteria for racial discrimination. The court stressed that the preamble and its definition was linked to the process of decolonization. It banned doctrines of superiority, whilst differentiation and nationality were very common then and now. So nationality or current citizenship could not be included in the criteria for racial discrimination. Let's go to the travaux préparatoires. Qatar brings here an argument from the travaux préparatoires, which is almost of a teleological nature. It said that actually the drafters sought a broad and comprehensive definition of racial discrimination, which would leave no vulnerable group without protection. And they did not intend to exclude nationality-based discrimination. Again, the court discussed the travaux of the drafting commission, which was the Commission on Human Rights, and of the third committee of the General Assembly, and it considered very clear that national origin does not include current nationality. And we come to the practice of the CERD committee, which is a very important, the most important point perhaps of the discussion, because the CERD committee had developed a practice for the last 20 years, in which it considered discrimination on citizenship or immigration status as coming potentially under the concept of racial discrimination if it did not pursue a legitimate aim and it was not proportionate to the achievement of this aim. And this is the general recommendation number 30, which has had a very large impact in many countries, in the practice of many countries. Perhaps the most prominent was the inclusion of an analysis of recommendation 30 in a judgment of the House of Lords in 2004, A and others versus Secretary of State, on the basis of which, and of other reasons, of course, the House of Lords declared the first anti-terror law of the Blair government as illegal and as inconsistent with the CERD and with other legal provisions. Now the court comes very radically against the committee by saying, well, it's a body of independent experts established specifically to supervise the application of the CERD, and well, that's okay, but even though we ascribe great weight to the interpretation of international treaties by these organs, the court is in no way obliged in the exercise of its judicial functions to model its own interpretation of the covenant or here of the CERD on that of the committee. It's a very radical and direct conclusion that the court repeats that, well, its previous thoughts are here applicable, and so the position of the CERD committee is not to be given weight in this case. Yeah, Qatar made some other arguments from regional human rights courts saying that under nationality they include also the current citizenship, but the court answered correctly here that well, these regional human rights treaties do not make any distinction between aliens and citizens, so then also nationality may include the current citizenship, but that's not the case with the CERD. Media corporations blocking of Al Jazeera, the court decided that the CERD protects individuals or groups of individuals, and the institution represented individuals, therefore NGOs, but not media organizations. And finally, it rejected indirect discrimination. Very, very briefly here, I separate one point which I find it fascinating. The court observed that declarations or whatever measures criticizing a state or its policies cannot be characterized as racial discrimination. Then I understand that as in a geopolitical conflict, here, for instance, in the confrontation between Saudi Arabia and others versus Qatar, so the measures of the Emirates in this conflict excludes the purpose of discrimination of a group of people, because it is about forcing another state to change its policy, and it's not about discriminating for racial reasons of any kind against individuals. So the conclusion is that the court has no jurisdiction. Voting pattern, it's impressive because the judgment, a very controversial judgment, was adopted by a big majority, 11-6. The 4 member states of the Security Council represented, judges from the 4 members of the Security Council represented in the court voted in favor. And even the ad hoc judge of Qatar, Judge Dode, voted in favor. That's another impressive moment in this very intriguing case. Against were a number of judges from developing countries, plus the judge Iwasawa from Japan, who apparently, and we can see through his opinion, that he invoked Japan's particular interest, historical interest on racial discrimination, because Japan was the first country to bring the topic in the period in the aftermath of the First World War. So there is a particular relationship between Japan and racial discrimination and the fight against it. And I think also that Japan wants to come back from its defeat in the case of the whaling case. So the judge has this sensitivity of trying to bring Japan back to the human rights protection and create different somehow profile for the country's sensitivities. Big question is, does this judgment has an effect erga omnes? Clearly the interpretation is unambiguous. However, it's not directly obligatory for third states. The ICJ is not at the top of a normative hierarchy, but it has the ultimate authority to interpret international law. However, I think that the definition is in a sense erga omnes, because racial discrimination belongs to the core vocabulary of international law. And we discussed the other time what happens with advisory opinions and human rights bodies. If human rights bodies adopt only recommendations, and if an advisory opinion is sufficiently clear, then I would say that it has, again, more authority than the human rights bodies. And I would ask myself, or we should ask ourselves, whether the CERD committee would be there, would be capable of denying the interpretation of the court and pursue its own policy, which I find it very difficult to legitimize. We have a discussion here in Germany about an amendment of the fundamental law. Is this amendment now, the discussion on an amendment, does the judgment have an impact? What about the critique and defamation of religious, for instance? It's irrelevant to the CERD. Migration critique and the questions of Volksverhetzung, for instance, do they have an impact? Are they need to be interpreted in a differentiated way following this judgment? Overall, I don't want to go further in that discussion, but there is a sense that the ICJ follows a broader path here of practice the infamous Muslim ban of Donald Trump. Donald Trump has won before the ICJ, before the Supreme Court of the United States, with a reasoning linked to the domestic law of the United States. Recently, we had a very, very restrictive migration judgment, Sanchez versus Mayorkas, US Supreme Court, delivered by the liberal Justice Elena Kagan, taking unanimously an individual has been forced to leave the United States after 25 years of stay in the country as being afforded temporary protection. So there is a general sense that the courts are restrictive in questions of migration. And a question that has to do with our political culture: does calling a person racist constitute criminal behavior more often than currently assumed? These are open questions. I don't want to go further than that. Just it's some material for our discussion. Thank you very much.